Hello, everyone. I want to thank you all so much for joining me today. This webinar is about estate planning, what it is, and why do we need it. So before we start, I want to talk to you a little bit about myself. My name's Catherine Hergenreiter. I grew up in Fresno, and I moved down to Orange County to attend UC Irvine, and I've been here ever since. I earned my JD at Whittier Law School and was on the Law Review as an articles editor. I've been a practicing attorney for 8 years now. It's crazy how time flies. Before I moved to the field of estate planning, I was a consumer debt attorney. I helped people resolve their private student loan debt, and although that was very rewarding, my number one passion has always been estate planning. I've been in this field for the past 4 years, and I absolutely love it. In my free time, I love to explore all Southern California has to offer. So if you do have any suggestions, please let me know. My husband and I have a 10-month-old feisty baby girl, and we just love taking her to new places every weekend. So on today's agenda, we will be discussing what is an estate plan and why do you need one. We will briefly go over what probate is. Then we will talk about what is included in an estate plan. And lastly, I'm going to go over estate plan alternatives and why they are not recommended. Okay, so let's start and talk about what even is an estate plan. Essentially, an estate plan is a set of legal documents that lays out your wishes and protects yourself, your family, and your assets. So who needs an estate plan? Almost everybody. Anyone who owns a house, a business, has minor children, has a disabled loved one. Anyone that has special wishes for their assets needs an estate plan. So what is an estate, you might ask? So your estate includes your real property, so your home and any other real property that you might have. You might have some rentals. It also includes your personal property, so your car, personal belongings, artwork, jewelry, and so on. It includes your bank accounts, your investments, so your IRA, your 401ks, and your life insurance policy. So even though that does not pay out until your passing, it's still a part of your estate. A lot of people wonder why they even need to plan. There are so many reasons that having an estate plan will best serve you and your family, but the main reason is to avoid the dreaded probate. If you own real property in the state of California and it's not in a trust, your estate will go through probate. This is not a test, this is reality. So if you do know somebody that owns their home and you know that they don't have a trust, you need to remind them to create one as soon as possible. Also, some people are concerned with taxes and they want to minimize their tax liability as much as they can. So if this is a major concern for you, please talk with your estate planning attorney and your CPA because there are tools that we can use to help minimize your taxes. Another reason is that people want to have control over their assets while they're living. So creating a plan for certain situations will accomplish that. One situation that is very common is what happens if you become disabled and you're not able to manage your assets anymore. You want a plan in place for when that happens. Everyone wants to protect and provide for their loved ones, and in your estate plan, you're able to lay out your wishes, what you want for your assets, meaning you get to decide who receives what, how they receive it, when they receive it. This also helps prevent conflict within the family that might otherwise occur if you didn't have a plan at all. You also need to have a plan if you have minor children. You want to name guardians for them should something happen to you. Also, if you have a loved one with special needs, you will need to plan for how they will receive their inheritance as to not jeopardize their government benefits. So why do I need an estate planning attorney? So families come in all shapes and sizes with different dynamics. Everyone's situation is unique. So you want to discuss your particular situation with an experienced estate planning attorney that will be able to recommend the best course of action for you. You may need specialized planning, for example, if you have a large estate, or because maybe you have a blended family, meaning you and your spouse have children from previous relationships, or maybe you want to disinherit a certain child for whatever reason. Or maybe you have a loved one that has special needs like we talked about earlier. But I think the most important reason to work with an estate planning attorney is to ensure that your goals are met, whatever they may be. Something like this is not a do-it-yourself project. So let's talk a little bit about why we want to avoid probate. But first, what is probate? In the state of California, if you die without a trust and you own real property greater than $50,000, which is everyone, or your assets are greater than $184,500, then your estate will go through probate, meaning a probate judge is going to distribute your assets according to the California Probate Code. This process can take years to complete and is very expensive. How expensive? So I created this chart to show you how much your estate could owe in fees. I'll leave it up for a little bit so you can check where you land right now. So you can see, let's say your assets are equal to $1 million. Then the fees could be at least $46,000. So that's quite a large chunk of change. And this is the money that your beneficiaries are not going to receive. So this is completely avoidable if you create an estate plan. So what does an estate plan include? I will go over each document in detail, but a complete estate plan will include a revocable living trust, pour-over will, general durable power of attorney, advanced health care directive, a HIPAA authorization, personal property memorandum, and a certification of trust. Depending on your situation, other documents may be necessary, such as documents related to your business. So what is a revocable living trust? A revocable living trust is a document that you create during your lifetime that will help manage your assets and protect you should you become ill or disabled. It's revocable, meaning you can change it or completely revoke it during your lifetime. It also helps your estate avoid probate, which we'll talk about in the next slide. It also lets you designate your beneficiaries, that is, choose who will receive your property when you're gone. You could determine how they receive it and when they receive it. So why do we need a trust? Of course, like I said before, the number one reason is to avoid probate. The dreaded probate. If anyone here has ever been involved in the probate of a loved one's estate, you will understand that it is a time-consuming, expensive headache that could have been easily avoided with a trust. Even if you have just a will, that will must be submitted to probate court so it doesn't avoid probate entirely. Also, if you want to leave your family with specific instructions, you would do so in your trust. The last thing your loved ones want after losing you is to deal with a probate or to not know what you wanted. That can definitely cause conflict within a family, so detailing exactly what you want done will help eliminate all of that. Is a will enough? No, absolutely it is not enough. The most common misconception that people have is that a will is enough to avoid probate, and that's false. So even if you lay out your wishes, make it clear what you want done with your assets, your loved ones will still have to take your will to court, and a probate judge will distribute your assets by the terms of your will. So the probate courts are still involved, and time and money is wasted. A lot of people don't realize that. So we still want a will, though, even if we do have a trust. And that is because you are able to state in your will that you want all of your assets poured over into your trust. So let's say you forget to title something in the name of your trust. There's a way to use your pour-over will to get that asset transferred to your trust. This process also involves the probate court, but it's much simpler. Another thing you can do in your will is nominate guardians for your minor children. If something were to happen to you, you don't want your children to end up in foster care while a judge determines who will care for them. And the judge may appoint someone who you would never want to take care of your children. Just think of Harry Potter as an example. The next document is the General Durable Power of Attorney, which I'm sure you've heard about. As opposed to the trust and the will, this document is only operative when you are living. It gives your agent the ability to manage your finances if you're not able to. That includes paying your bills, buying or selling assets, maybe in order to pay for your medical care, filing and paying your taxes, managing your investments. This document is very customizable depending on what you want and what powers you want added or deleted. It can be revoked at any time as well. The next important document is the Advanced Healthcare Directive, which is basically a power of attorney for medical decisions. Also in this document, you can decide what you want for end-of-life treatment, whether or not you want life support. You can also indicate if you are an organ donor or not, and whether you want to be buried or cremated. Next is the HIPAA authorization, which goes hand in hand with the Advanced Healthcare Directive, the previous document. HIPAA stands for Health Insurance Portability and Accountability Act, and it's a federal law that protects your medical information. You must specifically authorize certain people to be able to receive your medical information from your healthcare provider. So even if you're married, this authorization is not automatic for your spouse. You must specifically name them as an authorized recipient in this document. This will help your agent make decisions regarding your health care on your behalf. You can also specify who you do not want to receive your medical information, or if you want to limit the information that is given. The personal property memorandum is an optional document, but if you want specific items of personal property to be given to specific people, then you would list that here. For example, here, John Smith wants to give his gold Rolex to his son, Damon. So typically people use this document to pass on items of sentimental value. So the last document is called a certification of trust. So this is a short document that certifies that your trust exists without having to provide the entire trust document, which you may want to keep private for many reasons. You would give this document to your financial institutions in order to rename your accounts to the name of your trust. So I want to point out some popular alternatives to an estate plan. Mostly these are ill-advised and have many downsides that I will talk more about. We will be going over beneficiary designations, payable on death accounts or POD accounts, gifts, and transfer on death deeds. Let's talk about beneficiary designations. Many of you have probably already named a beneficiary for your life insurance policy, retirement accounts, bank accounts. Generally, for tax purposes, beneficiaries should be designated directly with your retirement and life insurance policy company. These will not be assets of your trust. However, an exception is if your beneficiary is a minor. In that case, you may not want them to receive it outright. You may want to control how they actually receive the property. For example, delaying it until they're 25. So in this case, you would name the trust as the beneficiary so that the proceeds flow through the trust and are distributed by the terms of your trust. Some cons relying purely on beneficiary designations are, one, you do not have control on how the property is distributed, since there's usually no way to indicate this. So they will likely just receive it outright, and that might not be ideal in many cases, like I just said about the minor beneficiary. Also, if you get a divorce, your ex-spouse is not automatically removed as your beneficiary. And let's say your beneficiary predeceases you. or dies before you and you did not name someone else, there may still be a probate. So next is the payable on death account, or POD account. This has been nicknamed the poor man's trust because many use this in place of an actual trust. There are actually several cons to relying on this method. First, what if something happens to you and you're still alive but you're incapacitated? Your named beneficiary does not have access to your funds to pay your bills. Actually, they have no rights at all until you die. Also, you cannot name alternate beneficiaries. So if your beneficiary or beneficiaries predecease you, the account will still go through probate. Also, a POD account is still subject to the claims of your creditors, so if you owe debts, those creditors can go after those accounts. And if your beneficiary is your child, a minor, then the court must appoint someone to manage the funds for them. Next is gifting property inter vivos, which means during your lifetime. So something people ask me all the time is, why can't I just transfer title to my child now as a way of not having to create a trust? That is never recommended. An experienced estate planning attorney will not allow you to do that. There are so many problems with this option. First of all, if you were to transfer title to your child right now, that's considered a gift. And not only do you have to file a gift tax return, but your child will lose the step up in cost basis, and they will owe more in capital gains tax when the property is actually sold. However, if you leave the property to them in a trust, then they will inherit the property. And inherited property does receive a step up in cost basis. So if they decide to sell the property shortly after your death, they will pay little to nothing in capital gains tax. Also, because of Prop 19, transferring title to your children will increase the property tax unless they live in the home, which actually we'll go over in a little bit. Another important reason that I never recommend this route is because it now exposes the property to your child's creditors or divorcing spouses. It happens all the time. So let's take a look at a few scenarios that will really show you why this is a mistake. So the first scenario, mom buys a house in 1995 for $300,000. Mom transfers title to daughter in 2021 out of fear that she's getting ill and old, and she thinks it's the easiest and cheapest way to make sure her daughter receives her home. Since the daughter is receiving the home as a gift, the daughter receives the mom's cost basis, which is $300,000. Now mom dies, and the house is now worth $2 million, not uncommon at all in Southern California. The daughter does not want the property, so she sells it because she needs the money. Her gain is the difference between the sales price and her cost basis. So she is realizing a $1.7 million gain. Depending on her income bracket, her federal capital gains tax rate could be up to 20%, and the California capital gains tax could be up to 12.3%, which means she could owe $550,000 in capital gains tax. So now let's take a look at what happens if instead of transferring title to the daughter in 2021, mom creates a trust and names her daughter as the beneficiary. So in this case, when mom dies, daughter receives a step up in cost basis because daughter is inheriting the property. The house is now worth $2 million. The daughter sells it and now realizes zero gain, which means she will pay nothing in capital gains tax, and she will receive the full profit from that sale. So, as you can see, this is why you do not want to just transfer title to your children. It is not in their best interest. So I want to talk a little bit about Prop 19 and what it did for families in California. So this law came into effect in early 2021. Before Prop 19, generally parents were able to transfer title of their real property to their children, and the property would not be reassessed for property taxes because of the parent-child exclusion. So this means the property would not be reassessed and the property tax would not increase. Prop 19 eliminates the parent-child exclusion, except for in this very limited circumstance. First, the property must be the primary residence of the parent and the child, so no rentals. And your child has to move in or live there within 1 year of the transfer of title. Otherwise, the parent-child exclusion cannot be claimed anymore, and the property will be reassessed to the fair market value, and the property tax will increase. So now let's take a look at that first scenario again, but from the property tax perspective. So mom buys the house in 1995 for $300,000. She transfers title to her daughter because she thinks it's easy and doesn't understand the tax ramifications. Her assessed property value is about $490,000, and she pays about $5,000 in property taxes annually. Now, daughter lives in another county. Daughter is not going to move into the home as her personal residence. So after mom transfers title to daughter, the house is reassessed to $2 million, which means the property tax now increases to $20,000 annually. So a $15,000 increase in property taxes annually. Do not make this mistake. And some of you might be thinking, well, won't the property tax increase anyway when mom dies because the daughter cannot claim the parent-child exclusion? Yes, but what if mom lives for another 10 years? Now she's going to owe $15,000 extra per year while she's living in the house. So with this increase in cost, they may have to now sell the property. So remember, the daughter has lost mom's cost basis. So there is also a huge capital gains tax liability of almost, well, $500,000 basically. So bottom line, this is one of the worst things you could do for your family. No professional would ever recommend this route to you. So last is the transfer on death deed, which I'm sure many of you have probably heard about. This is used to transfer property to a named beneficiary upon your death. So the statute was actually updated this year. Now it must be signed by 2 disinterested witnesses, and the beneficiary must notify all the owner's heirs upon the owner's death, and they're able to actually challenge the deed at that time. The deed must also be recorded within 60 days of the notarization date. So this all seems simple enough, or is it? The rules regarding this actually, because of the risk of undue influence, fraud, elder abuse, they are very strict. So any errors will invalidate the deed completely, and then it'll end up in probate. Also, title companies will not issue title insurance immediately. They will wait 3 years until after the death. So this means during that time, the beneficiary cannot sell the property. They can't refinance the property. Also, the beneficiaries predecease you. It will also end up in probate because you're not able to list alternate beneficiaries. And just like a POD account, the beneficiary has no authority over the property while you're living. So for example, they would not be able to sell the property to pay for your long-term care should you need it. So with all of this information, what do you do now? Well, the first thing I recommend is to review all of your assets, check your beneficiary designations, make sure those are up to date, and then give me a call for a free consultation. I would love to speak with you to help you protect yourself and your family. Right now, I'm going to open it up to any questions that you may have. Of course, I have to have my disclaimer. Remember that I can only answer general questions. I cannot answer specific questions regarding your personal situation. Those can be discussed at your consultation. Again, this is purely educational and is not meant to replace actual legal advice. So thank you all again, and I will open it up to questions.